I will now call People versus Brian Roberts.
Good afternoon. May it please the court. Heather Bergman, Assistant Prosecuting Attorney from Kalamazoo County, appearing on behalf of the people. I'd like to reserve 1 minute rebuttal time, please.
That's fine.
The people are here challenging the Court of Appeals decision in this case regarding a claim of ineffective assistance of counsel. As this court is aware, since its decision in 2015 in People versus Ackley, this has been a highly debated topic. And whether or not one agrees that there is a real medical controversy surrounding the diagnosis of abusive head trauma in children, when analyzing cases such as these and examining the need for an independent defense expert, appellate courts must judiciously apply well-established standards of review. And I'm hopeful that that is why this court was interested in this case in particular, because the Court of Appeals did not apply the correct standard of review. As this court knows, there's a long-standing state and federal precedent that protects the professional judgment of defense attorneys, and that there's been a heavy burden placed on a defendant to establish relief. They must prove both that the performance of their attorney was unreasonably objective, or objectively unreasonable, and that the prejudice that results undermines the reliability of the verdict. Now, while I think there's a lot to be said regarding counsel's actions in this case and the decisions that he made regarding how he wanted to proceed with his case, and this case in particular, I do want to focus primarily on the prejudice aspect of the case, because as this court noted in People versus Reed, quoting from Strickland, that the object of an ineffective assistance claim isn't necessarily to grade counsel's performance, and that if it's easier to dispose of an ineffective assistance counsel claim on the ground of a lack of sufficient prejudice, which the court expects will often be the case, that course should be followed. I want to start with quoting a portion of the Court of Appeals opinion, and it's found on page 10 of their opinion, where they look at the prejudice in this case. The court indicates near the bottom of the page of the slip opinion, moreover, had he, referring to the defense attorney, called his own expert or experts to testify that the child could have suffered the catastrophic injuries he did by losing his balance and striking his head, apart from a substantial or violent pull by the defendant, the jury might have been persuaded that the prosecution failed to prove that the defendant had a culpable state of mind when he grabbed his son's ankles and pulled him down. Might. That the jury might have been persuaded. That is not the standard.
Counsel, good afternoon and welcome to our first session. The government's witnesses were pretty impactful when you're talking about a child and you're talking about the fact that they testified to the fact that the type of trauma that this child suffered was equivalent to getting hit by a car or a sledgehammer. This is a case that really comes down to a battle of the experts. The defense counsel was basically called a pediatrician, which I don't really know what the benefit or point of calling a pediatrician when you're dealing with a situation that requires expertise on this area, coupled with the government's witness, which I still haven't quite understood what the point of that was. I mean, at the end of the day, I mean, when you're looking at Ackley, when you're looking at this court in terms of this, and you basically brought it up by using the word might, I mean, when you have a case that's a battle of the experts, and you don't even call relevant experts to contend with this, how is it not ineffective assistance? Because I don't understand what the strategy of the defense counsel was.
Your Honor, the issue here, so if you're looking at the case in regards to the facts as they presented itself in Ackley, or perhaps even a typical abusive head trauma case, this case is so different. This is a situation where the defendant admitted to the conduct that caused the injuries in this case. And also, the extent of the injuries were not contested. The only issue for the jury in this case was the issue of intent and whether the injuries were foreseeable. And that is the issue here. With regard to
So what would the strategy have been to not call a relevant expert? I mean, we're going in a circle. What was you would think that if that's in fact the case, I'm trying to understand what would the strategy be? What's the strategy of the defense counsel to not call any relevant experts?
The strategy, as the defense attorney indicated on remand, was that he looked at the case, he saw some weaknesses in the case with regard to the child having a large head or suffering from what's called macrocephaly, and he explored that. He consulted with a child abuse expert, Dr. Gerton here from Lansing, and I want to remind the court, this is not an inexperienced defense attorney. This defense attorney has 30 years of experience on both sides.
But you're not answering my question. I don't understand the strategy. The strategy is to do nothing? I mean, this is the strategy? The strategy is to call nobody?
I don't think that's a fair representation of the record, Your Honor. He didn't just do nothing. He used what he had, and he found out, he knew about shortfalls. He did not think it was a viable defense in this case necessarily. He had to deal with a client who told many different versions of what he said happened on the night in question. And if you look at the concessions that he got from prosecutors, experts too, all he had to do is create a reasonable doubt in this case. The defendant does not have to present testimony. He only has to create a reasonable doubt.
So is your answer to Justice Bernstein's question that his strategy was, I can create reasonable doubt without an expert?
Yes.
Is that what you're saying?
Because he knew going into the trial, as far as what he testified to, he knew going into this trial that he was going to get concessions, and I believe pretty important concessions from prosecutors, experts, that force was an issue that we could not determine with any specificity. That's basically what the issue was here. And with regard to the auto accident analogy, I think it's been unfairly characterized in both the cases that talk about abusive head trauma and how it's been characterized in this case on appeal. If you look closely at the cross-examination, when Mr. Solis, who was the defense attorney, asked Dr. Shattuck, well, come on, aren't you exaggerating? I mean, you're talking about an automobile accident in a train wreck. And she said, no, what she was looking at primarily is, because in auto accidents, that's where you get the kind of the essential components. You've got force, you've got velocity, and you've got impact. And she even conceded that she's not necessarily talking about a high-speed accident, that the speed could be variable. She's looking at just, and Dr. Dragovic confirmed too, you're looking at force and impact.
So can we go back to, so your answer is his strategy was he thought he could create reasonable doubt with his questions and with some of the other ways in which he argued to the jury about the evidence and the lack of evidence. Why would it be inconsistent with that strategy to also call an expert who called that into more question?
That's a great question, and I think that when you look at the expert's testimony here on remand, it's a perfect reason perhaps that the expert testimony would be irrelevant or not even helpful. And that's one complaint I have, Your Honor, about how the expert's testimony has even been characterized. I think that the defense was hoping for more compelling expert testimony, and perhaps there is an expert out there that could have given more compelling testimony in this case, but the ones that were offered, Dr. Dragovic and Dr. Mack, they didn't really offer anything more than prosecutors' experts conceded, that force was an issue. In the affidavit that was attached to the defendant's motion for remand to get a Ginther hearing, Dr. Dragovic represented in his affidavit that he would testify that this was consistent with an accident, that he would support the defendant's accident defense. He did not say that. When he testified, he did not say that. In fact, he admonished me when I asked him, so are you calling this an accident? And he said no, that he's never called this an accident. In fact, if you look at the testimony from those doctors, I think this is exactly why the defense attorney didn't take the risk of bringing one. Because
Well, that's not, you can't, I mean, he would have said that if that were true. You can't just make up facts.
He
here,
did
right?
say that.
No, he was asked, did you know about the science around shortfalls? Did you know that there were experts who would say that exactly how the defendant says this happened is consistent with the injuries that the baby suffered? And he said, no, I didn't know anything about that expert evidence. So he didn't do any investigation into this question.
I don't think that's a fair characterization of how he answered that question. He
All right,
actually,
well, I have the transcript. We can read it. But you believe that he answered that he did know about it and decided not to pursue it?
he indicated that he had actually some articles from Dr. Girton regarding shortfalls, and he discussed those articles with even Dr. Shattuck. So to be completely unaware that there's a shortfall defense, I think he believed that it wouldn't have been viable in this case.
But his testimony was, I did not know there was science supporting the statements that the defendant made. I mean, you think it's sufficient under Wiggins? The investigation he did is sufficient under Wiggins?
I think that, in all due respect, Your Honor, I think that we could debate all day about whether Mr. Solis did what he should have done regarding the standard. And that's where I think that it's easier to say that it didn't, no matter what he did or didn't do, there was no resulting prejudice in this case. Because even if you
So
consider...
you concede it wasn't reasonable trial strategy? And
No,
you
I'm not
also-
conceding that.
Okay, but you think prejudice is stronger?
In fact, I've argued strenuously that I believe that he did make reasonable efforts. And I believe that the trial court's decision finding the same should be given some deference. But I think, yes, I think the prejudice, the aspect is a stronger argument. Because if you look at the expert's testimony that was heard on remand, you have to ask yourself, would a jury likely acquit?
But
And that's not the standard that was
We'll never really
applied.
know, though, because
sorry,
we'll never really know because he didn't call anybody.
I don't think that's actually the right question. The right question is, Strickland says, a defendant need not show that the error more likely than not affected the outcome. A reasonable probability is simply a probability sufficient to undermine confidence in the outcome. That's actually the question that we have to answer.
Yeah, and I'm actually going to direct the court to a more recent opinion from the U.S. Supreme Court, Harrington versus Richter. And I think this opinion is important because it's essentially unanimous. Justice Kagan did not participate, but of the justices that did participate, even though Justice Ginsburg had a concurrence, she agreed with the standard. And in that case, the U.S. Supreme Court indicates that in assessing prejudice under Strickland, the question is not whether a court can be certain counsel's performance had no effect on the outcome, or whether it is possible a reasonable doubt might have been established. And that is exactly the standard that the Court of Appeals used, might have. The court indicates instead, Strickland asks whether it is reasonably likely that the result would have been different. They go on to indicate that the difference between Strickland's prejudice standard and a more probable than not standard is slight and matters, quote, only in the rarest case. They conclude by indicating the likelihood of a different result must be substantial, not just conceivable. And if you consider the expert's testimony in this case, I want to...
Do you think Harrington changed the Strickland standard? Is that
No,
your-
I think it emphasizes what it really means.
Okay, so you don't quibble with what I said the Strickland standard is?
No, but I disagree with how the Court of Appeals is characterized, and I also disagree with how opposing counsel has characterized it. They use the words...
I was just reading from Strickland. You don't disagree with me
No,
or Strickland?
I don't, Your Honor.
Good, cool.
Because both the lower court and opposing counsel have used the words might and could, and that is not the standard. This is a heavy burden, as the court has indicated. And I want to take a look at, so what did the experts then say here? You know, Dr. Dragovic talked about the fact that there was prior injury and that it could have made the child more susceptible to further injury. But then he goes on to testify that any injuries healed or not healed do not make any difference in this situation. He also says that the medical evidence is consistent with the defendant's version, but then indicates that he wasn't factoring any force in. He indicates that it's a possible scenario, but he couldn't outrule child abuse. How is that different than what the prosecutor's expert said? He also indicates here that when he was asked by defense attorneys on direct examination, is there anything about these injuries that necessarily reveals that they were intentionally inflicted? He answers, yeah, I'm concerned about one particular thing, the retinal hemorrhaging. And that's consistent with his literature.
Wouldn't all that make a lot more sense if the defense attorney had testified at the Ginther hearing? You know, the reason why I didn't call Dragovic is because I don't think he would have said anything helpful. If anything, it would have just emphasized the prosecutor's expert, so that's why I didn't do it. And instead, what we got was, I didn't know that such an expert existed. So I Googled and asked some questions.
I understand your point, Your Honor, but I don't want...
Wouldn't it be a better case for you if you had that testimony instead of the testimony
It
you
would,
had? Okay.
but that shouldn't... You've got to have both. You've got to have objectively unreasonable performance, and you have to have prejudice.
Agree.
And so if we're going to be caught up on what the attorney should have done or shouldn't have done, then we're forgetting the prejudice. A big component of the standard of review is being lost here. And I feel like the court is caught up on whether the counsel did or didn't do the right thing. The fact of the matter is these experts would not have changed the landscape. They would not have changed the jury's opinion because they conflicted each other. They conflicted even their own testimony. Dr. Dragovic says that shortfalls, he admitted that shortfalls do not typically result in these type of injuries. He admitted that. Okay? He said that it was possible that it happened in the scenario given by defendant, but then he admitted that shortfalls typically don't result in these extreme injuries. And he also indicated on cross-examination that he didn't have all the facts. I was shocked to find out that he was not aware of what the defendant told the police. He wasn't aware of the live-in girlfriend's account of what happened to the police or what she testified to at trial. And he was not even really familiar with the scene. The steps, the fact that he purportedly fell in a carpeted space, he was unaware of all these facts. And he admitted to me in cross-examination that that would matter. And then he says here, too, that he agreed that the majority of subdural hemorrhages identified in children do result from abuse. And he also indicated that literature supports the association between severe retinal hemorrhaging, which we did have in this case, and even detachment, which he writes in his Chapter 16 of Essential Forensic Pathology, that is typically related to abuse. So he, if anything, I think he would have supported the prosecutor's experts.
You guys should call him next time.
He offered little to nothing for the defense. And he also indicated, too, that he was concerned when asked about intentional injury, anything that would be intentional here. He was also troubled by the fact that there were multiple bruises. Because if you recall the defendant's story, which I think the irony of all this is this whole debate is on the premise that what defendant told, his last final story, was what happened. The jury likely did not believe that. But we're debating about what the experts were going to say about this shortfall when unlikely we even believe that's what happened. Why should we believe defendant's account, his third and final account of what he says happened in that stairwell?
Okay, I think your time is up, Ms. Bergman.
Okay.
Let me see if there are any further questions.
Well, I'm just going to ask one, and you've done an excellent job. I want to tell you, it's a pleasure to have you here at the court.
Thank you.
What I'm trying to understand, though, is, and I think Justice McCormick is focusing on it, too, is it's just, I like to kind of keep things simple and just boil them down. So here you have a situation where you have a child that I think has some special needs. You have a child that has a larger head, that has, some disability components that I think are relevant to our discussion in terms of the fragility of the child. And I think the essence of it, and I understand we're kind of going into different areas or different discussions, but the key here is that I understand what you're saying, but the question is, had you researched or done some basic legwork, you could have found, I'm certain, an expert that could have helped with the jury to have a better appreciation or understanding of the fragility of the child and what that means and what that represents. But to have no one that is able to testify to that is the thing that I'd like you to answer to, is that how is that not a concern, or how is that not something that we should be focused on as basically, is that an effective trial strategy? Is this not ineffective assistance? That's the essence. You've got an infirm child, you've got a child with what I think could be defined as a disability, perhaps, but again, it's uncertain or unclear. You don't have any expert testimony that's basically allowing for the jury to understand or appreciate the child's fragility. And that's the question here, when that's the emphasis or essence of your case, when you have a battle of the experts and you have the government experts saying one thing, which is pretty powerful testimony, you would admit, and then you don't have anyone saying anything else, the question here is, I just want you to take this one last chance to explain to the court, to help me to resolve my reservation as to how is that not ineffective?
Well, Your Honor, it's not ineffective because you've got to have both. You've got to have defective performance, and you've got to have resulting prejudice. So I understand, I completely respect the fact that you might be hung up on counsel's decision not to call an expert,
right,
or the fact that he maybe didn't, in your opinion, conduct a reasonable investigation to even determine whether he needed one or not. But you still have whether it mattered. Would the jury have likely acquitted had they heard from an expert in this particular case? Perhaps in most of these cases, it might be very relevant. Where in the facts in Ackley, where you go in and you have the representation from the defendant, you found the child unresponsive. In this situation, the defendant admitted to the conduct that resulted in the death of his child. The only issue here is intent. You've got a lying defendant. You've got many different factors in this case.
But the intent goes to the force, right? And that's what your experts testified to. So someone presenting another perspective in terms of the level, degree, and capacity of the force could have at least created some discussion, or could have basically allowed for people to pause before rendering a verdict.
Yeah, I think that, and I agree, force was definitely the issue here, but if you look at what Dr. Mack and Dr. Dragovic offered, they both conceded that they couldn't really testify regarding force. And that's the same thing that our experts testified to. And while both, in fact, I was looking at Dr. Mack's testimony again this morning, she never said this was consistent, the evidence was consistent with defendant's scenario. Dr. Dragovic said it was consistent, but he couldn't outrule abuse because he too could not give an opinion regarding force.
So it's my last question, I promise.
Sure.
So the question is, and this is, and I appreciate our banter, I appreciate our discussion, and again, you're doing an excellent job, because I know it's been kind of an intense discussion, but you've handled yourself beautifully, so thank you for that. But I just, again, just going back to this entire issue, if you had been able to do, and again, just answering the latter part of the question, if you had done some basic investigation or basic research into this, I understand we're talking about the same two people back and forth, but the idea that you didn't look into other possibilities or an explanatory witness or an explanatory expert, that's where I'm failing to see how the idea that wouldn't have a possible impact or have an effect on the jury's rendering, the simple fact that you present another side to this isn't relevant to this situation. That's what I just, in the last many moments that we have together, that's what I'd like you to explain to me.
I think, Your Honor, the point would be a very well-made point if the expert would have said exactly what you're presupposing the expert would say.
I see, okay.
Okay? So, but a lot of times, so this medical controversy that the court has been kind of bantering back and forth here for many years, and we've lived it here in the courtrooms too, at the trial level, the medical doctors are in disagreement. The majority of the doctors do believe this is a viable diagnosis. So finding these experts is not as easy as one may think, okay? From a trial perspective, in fact, from what I understand, Dr. Dragovic is not even taking these cases anymore. We've got cases that are pending where the defense has had a difficult time finding experts. But then you're presupposing that they're going to say exactly what you want. And again, just like Dr. Dragovic, he indicated in his affidavit that he would say that it was a result of an accident, but when he was actually questioned and push came to shove, he backed way off from that proposition. And in fact, he admitted that he could not outrule abuse because he could not testify with regard to the amount of force used. And you can't forget that it's not just a battle of the experts in this case. There was a lot of other testimony that I'm faulting the Court of Appeals for not considering. They look at the experts' testimony in kind of an unadulterated fashion. They don't consider what came out on cross-examination, and they don't consider all the other non-expert testimony that was presented that really showed that this defendant was in a very stressful kind of living situation. There was evidence of prior abuse, both verbal and physical, and there were a lot of issues that the jury had here to consider.
Counsel, I'll
Thank
call you to
Thank
an
you, Your
end a
Honor.
second time. Thank you very much.
Good afternoon. Erin Van Kampen of the State Appellate Defender Office, appearing on behalf of Brian Roberts. With me is my co-counsel, Michael Waldo. As has been discussed in the first portion of this argument, expert testimony about force, about the health of this child, and about the cause of his injuries was the cornerstone of the prosecution's case. Trial counsel did not realize that there were experts in some of these highly specialized fields, equally qualified, who would have provided testimony that supported the very defense he actually presented at trial. That these experts would have helped him prepare to effectively cross-examine the state's experts, and that their assistance and their testimony would have directly refuted the state's expert testimony on force, the health of the child, and the cause of his injuries. It is because of counsel's failures, the state's expert testimony went unchallenged and untested. The appellate prosecutor has just acknowledged that medical doctors disagree about these opinions about force, about whether retinal hemorrhages are diagnostic of abuse. But the jury never heard that. And it is for that reason that the Court of Appeals correctly concluded that trial counsel was ineffective. And that's why we ask that this court deny leave or, in the alternative, affirm. I'm happy to answer questions.
Ms. Van Kampen, I heard your sister counsel to pivot quickly to prejudice when we were talking strategy. Which might be a good move on her part. Can you address why you think this failure was prejudicial in this case, and what you make of the standard the Court of Appeals used?
Well, the Court of Appeals did apply the proper standard. The question of prejudice is a mixed question of fact and law that is subject to de novo review. That's clear from the precedent of the U.S. Supreme Court, this court, and the Sixth Circuit. They did cite the appropriate standard at the beginning of the very section that my counterpart just referred to, and that is that they found a reasonable likelihood that counsel's errors affected the outcome. The trial court, in contrast, applied the wrong standard. It said its job wasn't merely to determine whether there was outcome determinative prejudice, but whether counsel's errors wholly deprived Mr. Roberts of a substantial defense. That was an error of law and an abuse of discretion that the Court of Appeals was right to reverse. But beyond that, the prejudice here is clear from a fair reading of the record, and we've gone to some length in our brief to lay out some of the ways in which the so-called concessions weren't concessions at all, and the numerous other points on which the experts, like the ones we presented at the Ginther hearing, would have refuted the state's expert testimony at trial. So directing the court to page 29, Dr. Dragovich did actually say that the injuries in this case were consistent with Mr. Roberts' account, and he was provided with all three of the different statements. So it wasn't like he was giving that opinion in a vacuum. He did testify he was informed by myself of the differing accounts, and none of them were inconsistent with the medical evidence, and none of them without the assertions about force comparable to an auto collision or train wreck would have rose to the level of the requisite intent for felony murder here, which is what we're talking about. You know, Mr. Roberts' burden on appeal is not to show that he would have walked away free and clear from all charges, or that he is innocent. The burden on appeal is to establish that if the jury, which in this case heard only that every expert here agrees the force he used was abusive, comparable to a train wreck, that this child was healthy, and that these injuries, retinal hemorrhages, the chronic subdural, are diagnostic of abuse unless you prove otherwise. I mean, this testimony was so powerful that every time the prosecutor talked about intent in her closing, she tied it to the medical evidence. She urged the jury to consider that Nehemiah was talking to them through these experts, and that he hoped they convicted him based on their 88 combined years of experience in the field. In the face of that kind of powerful testimony, for defense counsel to proceed on a theory that did have available expert support without actually presenting that support left the jury with only one option. And there is a reasonable likelihood, which is less than a preponderance of the evidence, that one juror, in the language of Wiggins, a reasonable probability that even one juror, hearing that this evidence was actually contested and in dispute by qualified experts, would have struck a different balance. And that's why we do believe the record here conclusively shows prejudice and that the Court of Appeals correctly analyzed.
Ms. Van Kamp, I'm trying to understand one element of the evidence in this case, I guess the other evidence, not directly related to any potential disagreement among experts, I think. That's the fact that Nehemiah had a weeks-old subdural hemorrhage, and he was in defendant's custody during most of that time, I believe. Is there expert testimony that is available, that might have been available in your opinion, that would have contradicted, I guess, the suggestion of the prosecutor that while perhaps one subdural hemorrhage could have been caused by an accidental fall, that multiple subdural hemorrhages were much less likely to be attributable to that? Am I misunderstanding this as a significant aspect of the case against the defendant, that there were multiple subdural hemorrhages?
You are correct that that was a significant point emphasized by the prosecutor throughout the trial.
Not by the court, interestingly. It was not emphasized, interestingly, by the court itself in either its opinion or its order.
In the trial court opinion?
Yeah.
I do believe it was mentioned as one of the sort of pieces of evidence it found.
I didn't see that. Perhaps you're right, though.
But I do think the testimony that was presented on remand undercuts the state's representations about the significance of that chronic subdural on two fronts.
Please? How does it undermine that?
So first, Dr. Mack, who is a pediatric radiologist, specializes in reading CT scans of children and other kinds of imaging. She not only testified that a child can suffer a potentially fatal injury from a minor impact, but she also testified that the September CT, which Dr. Dunn testified, showed that Nehemiah didn't have an acute hemorrhage. Dr. Mack said you can't conclusively rule out a small chronic subdural from the CT alone, and the child was referred for an MRI that never happened. So the prosecution presented this child as a normal, healthy child, and it used expert testimony to do that. If trial counsel had consulted experts with the appropriate specialties and backgrounds, he would have learned that that premise also was rebuttable. Second, both Drs. Mack and Dr. Dragovich testified that the presence of a chronic subdural actually makes a child like Nehemiah more vulnerable to a significant injury from a minor impact. not because of a rebleed. I mean, there was an impact here, but the question is how much force was used to cause it, because that is the million-dollar question for the prosecutor to be able to show intent.
Just so I understand, a chronic subdural hemorrhage, is that the same thing as multiple hemorrhages? Is it a continuing hemorrhage, or does it indicate that there are recurrent hemorrhages of some sort?
No, I apologize. I've gotten a little caught up in the technical jargon, but a chronic subdural is an older collection of blood in the brain that is, it's not continuously bleeding into the brain, but its presence makes it compromises the brain. It makes the child more vulnerable to a significant injury from a minor impact. And so what Dr. Mack is saying, that chronic subdural that Dr. Castellani testified about, that's something that Dr. Castellani asserted, basically made this a certainty to him, that this was child abuse. And what the defense experts actually said, if anything, that makes it even less clear that there was a lot of force necessary to cause these injuries. And one other point, have I addressed the court's question?
I appreciate it. Thank you.
Thank you, Your Honor. I think there's one other significant part of Dr. Dragovich's testimony that would have been extremely helpful to the defense that has been overlooked by the trial court and the prosecutor on appeal. At trial, the prosecution suggested that none of Mr. Roberts' accounts was what happened, but that something else had happened that the jury would never know. But whatever it was, Mr. Roberts exerted a level of force that was characterized as angry, abusive, and comparable to a train wreck or an auto collision. But Dr. Dragovich said he could conclusively rule out violent shaking and slamming as the cause of injury because Nehemiah was not an infant. He was a 40-pound toddler. And to violently shake and slam a 40-pound toddler, there would be some sort of injury at the point where the child was being held. So if Mr. Roberts had actually piled drive Nehemiah into the floor, as one of the defense experts suggested he might have, you would expect to see bruising or a broken ankle, and none of that existed in this case. And that's what Dr. Dragovich was referring to when he talked about the singularity of the injury. And so that is something that would have been very powerful for the jury to hear in a case where they heard expert after expert after expert say, the science shows he intentionally inflicted abusive trauma comparable to an auto collision on his son.
Counsel, can I ask you, thank you for addressing prejudice. Can I step back now on the strategic prong? First of all, do you believe that People v. Ackley was anything other than an application of the Strickland case? And do you believe it stands for any per se rule that now binds defense attorneys to always have to find an expert in any case where a child has been injured?
Not at all. We are not asking the court for a per se rule. We're asking, and I don't think that Ackley actually broke new ground under Strickland at all. It was the straightforward application of Strickland in a case that happened to rest on complex science, which is something we see more and more in court, right? Trial attorneys need to educate themselves about the science that the prosecution rests its case on in order to be able to effectively represent defendants. But it's not even Ackley that set this. I mean, this is Trachtenberg involved a similar analysis of an attorney's failure to investigate science underlying the state's case and found that he consulted the wrong kind of expert for the case.
Yeah, I think of this case as more of a Trachtenberg case than an Ackley case, frankly. I don't know if you just, it sounds like you don't necessarily disagree with that. But more specifically, I mean, can you imagine an abusive head trauma case where a defense attorney could perform competently, and you would not be in front of us, and not, call an expert to the stand? I mean,
that is certainly a possibility, but this is not that case. Because of the centrality of the expert's testimony about force, that this child was healthy, because of the way the prosecution relied on that to meet its burden on intent, in this case, counsel, and the fact that, this was an attorney who may have been very experienced, but he'd never handled an abusive head trauma case before. He'd never once represented a client or prosecuted a defendant in a case involving a diagnosis of abusive head trauma. He, at least at some points, admitted that he was not familiar with any controversy involving abusive head trauma. And this notion that he somehow made a strategic decision to forego presenting testimony like we have received from Drs. Mack and Dragovich in order to just score some points on cross, that moment is a fiction. It did not happen. That's the exact kind of post hoc rationalization that Wiggins prohibits, because trial counsel did not know that such experts existed, and that was clear from his testimony at the Ginther hearing. He said he didn't know that there were experts available who would have testified that Nehemiah's injuries were consistent with his client's account. And when asked further questions about that on cross, he said, if I'd known, I would have said, give me their name and number. And that is why his failures weren't the result of strategy. They were an oversight that directly followed from his inadequate investigation. And that's another place where the trial court erred in its analysis, sort of along the lines of the error the court recently addressed in Pippin.
Okay, thank you very much, counsel.
For all of the reasons we've laid out in our brief, we strongly urge the court to look at this record. This is a case where the adversarial system did not work.
I think we have enough right now, thank you.
Thank you, Your Honors.
Thank you. I think, is time up?
Yeah,
Okay, please proceed.
it was way up.
Yeah, I'm sorry, it must be up. Oh, I thought you were shaking your head in response to my question. I'm sorry, your time is up. You've gone over considerably because we had quite a few questions for you. Thank you both, counsel.